Hi, Ben Weber, 3 Blossom Court, Westerly, Rhode Island. Thank you for allowing me to speak tonight. First, real quick, I'd like to say a little bit about the lighthouse property and the letter from the commission. And I just wanted to let you know, we have found overwhelming evidence that Lighthouse Road is in fact a public road. Not only that, is it also an easement, a separate easement to go along with that. So there would be 2 reasons why nobody should be blocking it off by security and saying that it's a private road. And just so, Council Liller, I think you were misinformed. I took a ride down on a Saturday when the museum is not open. It's only open 3 days a week for 2 hours. And it wasn't open on a Saturday, and they were there posted up, preventing the general public from going down a public road with an easement. So anyway, there's no link between the museum and, directing traffic for that reason. Next, it's with a heavy heart I have to sit here and literally give a background information as to what's been transpiring the last 3 years, that me and a lot of dedicated members of the public have committed their lives and their time to extensively research these rights of ways and provide any and all information we could for the purpose of conserving them and protecting them for future generations, just like it says in our harbor management plan, just like it says in our comprehensive plan, just like it says in the town ordinance, local law, state law, the Rhode Island Constitution, even federal law. And I'd like to remind the council that every single one of you came up here and you swore an oath to protect all of those, to uphold all laws, the Constitution, and to put, unfortunately, everybody has an opinion, but you guys are representatives of the people. You swore to put your opinions aside and represent what the majority of the public wants. So examples of what has happened. We have a lot of stuff that's been in the works. First and foremost, I'd like you to know, since the 1940s, statistically, we have actually lost 4 rights of ways. Now, I did the numbers. I can't remember, read off exactly which ones, but I was responsible alone for adding one. The east side of the breachway to Fenway Beach. That was me alone. I added one. There was only 3 others that were added since that time. But in that time, so many have been taken away. We're actually -4, if I'm not mistaken. Okay. So what have we done? Spring Avenue. And I'm sorry this turns into this, but Spring Avenue, we provided a pictorial timeline. We researched, we did Solicitor Conley's work for him. For Spring Avenue, of which he's representing the town, he provided absolutely no research, no documentation, and did absolutely no work. As a matter of fact, said that it was not a right of way. There's information that we got from an APRA request that show Tommy Ligori's financials, where it literally states on April 29, 2021, finished the draft memo in email to Bill Conley. So at that time, Tommy Ligori was writing up his 150-page paper to submit to CRMC. And apparently, and the key word is draft, he emailed his draft to Solicitor Conley. Now, I would ask the question, why would a opposing counsel email a draft to the other opposing counsel? I understand after you finalize it and you file it, you can submit it to the opposing counsel. That's called disclosure, but not a draft. There's another submission of Tommy Ligori emailing Anthony Palazzola's letter. Take that for what it's worth. It doesn't, if you're sitting there emailing drafts and stuff before something is filed, that is something that somebody that is working with somebody would do. Mind you, I just told you, he didn't do any research and he didn't provide anything on Spring Ave to CRMC, not one document. Ninigret Ave, the sand trail. We all know that there was a contempt hearing for that. We all stood before you and said, that's great. They opened it up. We never would have got a chance to go after the 1997 consent agreement if they didn't open it up. No judge would want to overturn another judge's ruling, right? The 1997 consent agreement was entered in illegally. The town didn't have the right to abandon a public road that the commissioner, highway commission, accepted as a public road. You all know that Exhibit C miraculously was withheld from you, which is the email correspondence from Conley talking to Ligori saying, oh, it was just a mistake, don't worry about it. He went to that courthouse for that hearing and did the exact same thing he said on his email. He didn't say a word about the 1997 consent agreement. He agreed with Ligori, and Farside tried to jump on it, and thank God the judge didn't stuck to what was before them and didn't like his tone. So they didn't squash the sand trail Ninigret Ave completely. By the way, all of the stuff that we've gathered, Ninigret Ave is an accepted paved public road, and we have provided numerous documents to that. Fort Road, you guys are in a lawsuit. You're getting sued for Fort Road. Solicitor Conley penned his answer. I would have to beg the question, why, you know what, I represented myself one time, and when I was trying to do that, the opposing counsel, I was literally working from the handbook on civil procedure. The opposing counsel set and came after me with every procedural thing they could come up with to try to get it dismissed. They didn't succeed. They settled. Okay? That's what lawyers that work hard do. They try to defend their client. Why hasn't a motion to dismiss on the fact of its frivolous litigation, considering the 2008 council declared Fort Road a right-of-way? And they went, that was an agreement that the Watch Hill Fire District and the town came up with instead of declaring Fort Road as a public road. Finally, we're in a situation where we've come up to this podium. We've done all the work for him. And even on the Spring Ave issue that's before CRMC right now, we dropped all that research, hard research. We wasted our time on all that hard research. If it's all going to go in somebody's hands that wants to not do the job, not do the work. This is really important stuff. Rights of ways are our only legal means to get to the ocean for the public. The only way we can exercise our constitutional rights or our inalienable right to a natural resource, to fish, to clam, to feed ourselves, for enjoyment. Thank you for your time.